Linnell, thanks for having me here. I really appreciate everybody coming. Some of you had to push through a couple of presentations, and this one today is slightly different. But before I get into that, a little bit more introduction of myself. I am a practicing attorney. My office is in Byrd. I was brought down from Oklahoma by Diamond Shamrock back in '99 to be the risk manager for Diamond Shamrock. After the Valero merger, I went back into private practice. And before that, I was with Phillips Petroleum doing risk management work. And then prior to that, I was a judge in Amarillo. And we'll tie back into that in a minute. I do need somebody to be prepared to read out loud Article 6 of the Constitution. Can anybody volunteer to do that? Okay. Wade, is that right? Clyde, I'm sorry. I'm sorry. And I'm a CPA also and a trial attorney. So this subject came to me via a phone call from Frank Gaffney's group, the Center for Security Policy, a couple of months before the effort that we ended up failing at, and that was in April of last year, that Linnell mentioned, where we were trying to get American law for American courts passed. I was not prepared. I don't think any of us were prepared. The Muslim Brotherhood was there, and they were prepared. We were short a couple of votes, but that experience rankled me greatly. And so I had decided to stay on task with that. Since that time, actually Act for America has asked me to be retained as counsel for them as well. So I actually serve as counsel for the Center for Security Policy as well as Act for America. So I know we're all in great company here tonight. I'm happy to be here. I am assuming that most of you, if not all of you, are fairly well familiar with Sharia. If you're not, raise your hand and I'll back up a little bit on what I'm going to say. And it's okay, because a year and a half ago I didn't have a clue what Sharia was, or 2 years ago anyway. Everybody's pretty good with fundamentals there. Would anybody disagree that it may actually pose the greatest threat to our liberty that we see today? Would anyone disagree with that? No one for immigration or anything? Okay, all right, great. Well, having said that, let me cover what I'm going to do very quickly. Is I'm going to cover just some high-level fundamentals. I'm going to move into some case law. This time around, I'm going to do it a little differently than before. I'm going to take our proposed legislation for Texas, our exact proposed legislation. I'm going to break it into 5 parts. Those are 5 main parts that I will then illustrate each of those parts with a case somewhere in the country. So that you can see how, if that law was in place there, this kind of thing wouldn't happen. I'm doing that to try to draw a little bit better nexus, because I know this is complicated stuff. Even though we're dealing with just a section of all things Islam, it's still very difficult. So we'll cover those 5 components of the proposed legislation in Texas, illustrate them with some cases. I'll do a quick constitutional comparison. We'll then move into what happened last April. We'll talk about what the opposition had to say. And then we'll talk about some other proposed legislation and what to do. And then I'm happy to cover some Q&A. So does that sound good? I forgot to mention, who's been doing the ice bucket challenge? Somebody sent this to me and I thought it was pretty cute. So after Nancy Pelosi did the ice bucket challenge, that's all that's left. Somebody left out the critical broom. I don't see that. Okay, so what is Sharia? It is actually the legal code of Islam. It is the source of all Islamic jurisprudence. It differs from our laws because By the time you apply Sharia in a idealistic manner, which it is the source of, it's basically a theocracy, it will address everything associated with your life, except for perhaps when you go to the restaurant. And I'm not trying to be funny with that. All things you dream about, you think about, your relationships with family, friends, your children, your vocation, what you're doing today, what you think about doing tomorrow, your religion, your education. If you think about what it covers really everything you think, say, or do, and beyond. I tell folks, if you'll think about where Hitler was at, and if you ponder the fact that if you were Hitler and you had his machine, his theocracy, and you add a religion to that, that's basically what you're dealing with if you then shoot it with some steroids. That's kind of it in a nutshell of what we're dealing with here. And that's a very scary thought, because there is no self-government that's associated with Sharia. It's all external. Okay? Now, the doctrine of Islam actually means submission. And we'll get back to that in a little bit. But Sharia comes from about three main places. It comes from the Quran, as we might have guessed, but the interesting thing is only about 14% of that it originates from the Quran. The rest originates from what I would say all things Muhammad. You know, the Sirahs and the Hadiths, which speak to his actions and sayings and biography, things of that nature. It's important to note here, for a reason coming up, that while there are at least two Qurans, they actually mirror the phases of Muhammad's career, which began in Mecca, as far as where the context is important to us. And after the first 13 years or so, after attempting to be a philosopher, or I guess that's a good enough word for now, he really didn't get very many followers, 150, there's various accounts, less than 200. Then he moves down to Medina. But during that first period of time, he had a lot of writings, and that's what we refer to as the Meccan Quran. It's kind of the friendly, peaceful, let's all coexist, be tolerant. It's kind of that Quran, all right? But the other one comes up from his writings in the tail end of his career, the last 10 years, when he moved down to Medina and then switched from a religious perspective to a political perspective. Now, within the political perspective, that agenda, you've got nonviolent and you've got violence. And we see both of those once the Medina campaign began. And then he died after that. So, but it's interesting because that, even in his life, that history created the dualism that we now see in the Qurans. And so dualism is where we have two things that can't coexist but do, like peace through submission type of thing. So, and abrogation comes from that. The Medinan Quran will abrogate most of the time the Meccan Quran. So in the Meccan Quran you might see phrases like, let's be tolerant, coexist, and things like that. And then in the Medinan writings, you'll see just the opposite. Death to the kafar who will not convert, pay taxes, and die, that type of thing. So we've been seeing a lot of that in the news lately. I've left you here a website that gives you a really good illustration of this dualism that I'm talking about. It's enough4now.tripod.com/Mecca and Medina.html. And I'm happy to keep this available later on. A kafar would be me. That would be a person who absolutely rejects Muhammad and rejects Allah. I reject the notion that Muhammad was the last prophet of Allah. And I reject the beliefs, and the things that we should think about is that's not a passive term. That is a term of hatred. A kafar is to be hated as an enemy. It's well beyond the infidel. The kafar actually is a term that makes you a target once you're labeled as a kafar. Jihad is required by Sharia. This is a notion that I did not understand before. I fell into the group of folks that pondered that jihad was really just the violent part of Islam, the part that we see dramatized in the news. But it's actually not. For example, a year ago in April, when the Muslim Brotherhood was there and was literally lying to our senators, that was jihad. Was it violent? No, but it was jihad. And jihad is a gross term that really is dealing with the struggle against the kafar, and the purpose of it is to establish a complete Islamic civilization, a caliphate state. Some of you may have heard that term. It was also developed by Muhammad, as I mentioned, to make war against a non-Muslim to establish that religion. As much as I've been reading about this, I will also pose to you this notion. I don't believe at this point in time that Islam is all religion. I believe that a fraction of it is, and the rest is nothing other than a theocracy that deals with government, economics, and just a total taking over, if you will, of a civilization's, all of their infrastructure, institutions, and things of that nature. Primary target, though, is the Jews and the Christians. Okay, well, I've kind of talked about political Islam a little bit. This is a quote from one of the hadiths. I have been ordered to wage war against mankind until they accept there is no God but Allah, and I am His prophet, and accept all revelation spoken by me, that being Muhammad. When they do, I will protect their lives unless otherwise justified by Sharia, in which case their fate lies in Allah's hands. We've already talked about the Meccan and the Medinan Quran. Here's another point about dualism. Two things which contradict each other can both be true. Some of you are looking at me with some quizzed looks, and that's good, but that's actually the way it is in Islam. Peace through submission. Now, I've mentioned, or I may not have mentioned, dawah. Dawah is kind of the forceful arm of jihad and Sharia, where it's the proselytizing of Islam, and it is the inviting the way to submission. The purpose of it is to establish the caliphate, and in this case I put restore the caliphate, that being the rulership of Islam. I've got a couple of slides that are undercover audio video for you, and that's the reason for the sound and so forth, and hopefully all that will work.
This religion, that is Islam, it shall govern the whole universe. The Islamic civilization should rule and govern and direct people in every walks of life, but not to be governed by others.
Okay, this is Kamal Hawabi. He is currently with the Muslim Brotherhood, high ranking in that organization. And he states, this religion, that is Islam, it shall govern the whole universe. The Islamic civilization should rule and govern and direct people in every walk of life, but not to be governed by others. Now, where in there do you see any room for coexistence?
Here, Qaradawi tells an audience in Ohio about the group's goals to conquer the world, including the United States.
الفتح بالدعوة هذا ما نأمله إن شاء الله. سنفتح أوروبا وسنفتح أمريكا لا بالسيف ولكن بالدعوة.
Did y'all catch that? Read, everybody get it. Read it. Conquest through dawah. proselytizing. That's what we hope for. We will conquer Europe. We will conquer America. Not through sword, but through dawah. Now later on we'll talk about dawah by the ballot or the bayonet. Okay, that's just a little bit of a preview as to why we now are seeing what we're seeing in our courts. I just wanted to lay that background for you, because while we were talking about violent jihad, I'm going to suggest to you that jihad is just as gnarly. In fact, some might argue more so when it's the nonviolent, because it doesn't capture people's attention, it doesn't make the headline news, and it goes on an incremental level, one day at a time. And before you know it, it's there. So at this point, actually when I started this study, we had 26 states in the Union. That would actually be less than half of our states in the country, according to our president, that had about 50 cases. But now we're up to almost 150 cases in 32 states where comedy has been given to Sharia in one form or another. Now when I bring the word comedy up to you, let me mention, that is the giving weight to a law or another source. It'd be like if I went into the courtroom, as Daniel Webster used to do, and give argument and read from the Bible and make argument for law based on the Bible. If decisions were made from that, then you could argue that comedy was given to the Bible. So it's the same kind of thing where we see Sharia law being given comedy in our courtrooms. Most of those cases cover family law cases. That's why right now our proposed legislation in Texas focuses in on family law matters. However, we'll see a case here. Actually, I've got two, if we can get to it, where that are outside of the family law context. And it really, as I mentioned before, when we talk about covering all walks of life, we are seeing cases now that are from all walks of life. I had one sent to me the other day involving Abercrombie and Fitch on employment law. And it's a big case. And they won that matter, but it's scary to even have the trial over it. So right now, as Linnell pointed out, we do have 9 states that have passed American law for American courts, type legislation, model legislation in some cases, those being Tennessee, Louisiana, where Christopher Holton's from, Kansas, Arkansas, Oklahoma, North Carolina, Alabama, Florida, and Washington. Now there's about another dozen that's on the drawing boards this next legislative season, including Texas. What I want to do here, this is the exact wording, word for word, of what we tried to get passed last session. So the reference is to Senate Bill 1639. We do have a House bill sponsor from our good Representative Jeff Leach, and then we've got Donna Campbell, who is she was co-sponsor on the Senate's side last time around, and the sponsor, John Corona, was defeated. And so Donna is going to step up and sponsor this. So the 5 parts start off this way: a decision based on foreign law. A court of this state may not apply foreign law to adjudicate a suit affecting the marriage relationship or a suit affecting the parent-child relationship if the application of the foreign law would not guarantee the same fundamental rights guaranteed by the United States Constitution. Now, I have a footnote there, Texas. In the earlier drafting last year, in the last session, we did have Texas in there. But it was considered a worthy idea to take Texas out just to get the bill to go down the road a little bit. I never understood that thing. I do not understand why we have lawmakers who can't accept that we have a Texas Constitution. and at why that Constitution couldn't stand side by side with the U.S. Constitution in that bill. Right now, 2 weeks ago, we got some pushback to take the word fundamental out. And we pushed back and said, no, we're not taking fundamental out. Fundamental needs to stay there, and there's a number of reasons for it. So this is talking about a decision made in the courtroom that is based upon foreign law. So it's applying foreign law to make a new ruling. Okay, this is not talking about a foreign ruling. We're talking about a ruling that's going to happen here in Texas. And presumably it's going to be over a Texas citizen. Now some might say, well, there is no such thing as a Texas citizen. I disagree. At any rate.
They're not from Texas.
The Chistopher case is a case that I selected to illustrate this. We had here years ago a man and wife that were married in Pakistan. He later went on to school to become a doctor and a successful one. They moved to New Jersey. Now, later on, they went back to Pakistan, and he left her there. And he left her there on purpose and would not allow her to come back. Then he went back to New Jersey. And during the marriage, there were 3 children born. One of them was born in Connecticut. So now we're talking about a U.S. citizen-born child that's involved in this as well. While she was stuck in New Jersey and couldn't get out of there and had the 3 kids, he sends off to the consulate in New York for a tallit divorce. Now, a tallit divorce harkens back to Mosaic law, where you basically say, without any kind of a hearing, there's no due process, no equal protection, I divorce you 3 times. He does that through the consulate in New York while he's in New Jersey. Then he sends that to her. Now, tallit divorce is obviously Pakistani law. Now, this is going on in the United States. So, and I might add that I had an experience back in '87 when a gentleman came in, up in Amarillo, dragging his wife by the hair, 2 children in tow, and all we could make out was DeBoe, 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 over and over. We couldn't figure out what he was doing. And he was actually performing a tallit divorce. We set him down and said, you're in Amarillo, Texas. We don't do that like that here. By the way, she does get counsel. And you're not divorced, even though you think you are right now. And go seek help in more ways than one. And that was in '87. So little did I know that experience that one day, which I forgot about for a long time, would come back and have application here. So she then files for divorce, and the trial court judge, he sides with her, and he gives her an equitable division of the community and alimony, spousal maintenance, and all that, and along with custody. So let's look at what the appellate court then did. They applied Pakistani law, reversed the trial court's findings and award, even where the trial court judge awarded her with a divorce. The trial court judge in this instance did not recognize the tallit divorce. In fact, he made the statement that it was so offensive to New Jersey public policy not to even recognize it. So the appellate court comes along, reverses all that, reverses the award of spousal maintenance, child support, division of property, and enforced the tallit divorce, stating that she was not entitled to an equitable equitable division of property by reason of what was called an anti-nuptial negotiated by her parents. So you see here, this is where a actual judgment, a ruling in the United States, in New Jersey, was made based on Pakistani law. So that's an example of where this first part of the proposed Texas legislation, had it existed in New Jersey, wouldn't have happened. All right, the next part of that is any contract provision requiring the application of foreign law to adjudicate a suit affecting the marriage relationship or a suit affecting the parent-child relationship is void to the same extent the application of foreign law would not guarantee the same fundamental rights guaranteed by the United States. So here we're talking about the application of foreign law to actually adjudicate the suit through a contract. So this is a contract provision, as opposed to before we didn't have a contract issue there. This case is a Texas case, the Amid case in 2008. And what we had here was I believe they were from India, and there was a 1999 marriage that was a civil ceremony, and then it was followed by a religious ceremony 6 months later. And at the religious ceremony 6 months later, she was forced to sign this agreement called a nakinama. And in that, it speaks to a mar. And a mar is the Sharia law version of a prenup. It in no way mirrors and has any of the disclosure requirements that we require for a prenup to be honored in the state of Texas, which incidentally was against public policy for a long time until new legislation came along and set forth some parameters. Once those are met, then it can be recognized. So in that, she was given a deferred $50,000 award. So she comes along years later, and they're back in Texas, and he had found that the deferred mar was a binding premarital contract and gave her the $50,000. Now he gets apparently the short end of the stick of this deal, so he ends up complaining about some very interesting things. He says that the mar was a religious agreement that violates the Constitution. He says that it encourages divorce and is therefore against public policy, and complained and took it up on appeal. And the appellate court, in my opinion, instead of dealing with the heart of the matter, looked at it and said, well, trial court judge, how do you do that when you know that that mar was signed 6 months after they were married? The civil ceremony was 6 months before. The religious ceremony happened later. So how can you tell us today that they entered into a prenup, if you will, 6 months after marriage? And so then they reverse it on those grounds. But you see, my preference would have been for them to have gotten the heart of the issue. And they skipped around it. All right, here is a third section of the proposed Texas legislation. A court of this state may not enforce, grant comity to, a finding, ruling, order, or judgment on a suit affecting the marriage relationship or in a suit affecting the parent-child relationship if the foreign law, as applied, did not guarantee the same fundamental rights guaranteed in the U.S. Constitution. Now, in the first one, we were talking about an instance where the judgment hadn't been made yet, remember? And then in the second, we're dealing with a contract. Here, we're talking about where judgment's already been rendered from a foreign land. And the judge in Texas, in this case, is being asked to enforce that. So now we're looking at, well, Judge, can you enforce that if you can't reconcile the background of that to fundamental constitutional rights? So that's what this is getting at, this section here. Here's a case to illustrate. This is the Hussein Malek case out of Maryland. In this case, the mother and children fled to Baltimore after she heard that her husband was going to do a tallit divorce. So the trial court judge accepted the fact that she lived in Baltimore for 2 years and had established residency in invoked jurisdiction of Maryland, and he granted jurisdiction to her, and then proceeded on with the divorce as normal and gave her an award and so forth. The appellate judge came, or the appellate court came back, and what they had to say is really disturbing here. They completely reversed, remanded, and then they gave the trial court judge some very strict orders. They told him that he had to enforce the Pakistani version of best interest. Now, under Sharia, you cannot have a child raised by a non-Muslim, for example. However, under Sharia, best interest would dictate that the child has to be raised by a Muslim. So here, the appellate court is telling the trial court judge, you need to decide this based on Pakistani law, and you need to find out what best interest is under Pakistani law. And they went ahead and made some very interesting statements. They issued, under Sharia law, sole custody to the father. They returned the daughter, who was 7, and they even found that she did not appear under the proceedings in Pakistan because he'd done a talaq divorce. And they make this statement. They ruled the best interest of the child should not be determined based on marital law, American cultures and mores, but rather on applying Pakistani customs, culture, and mores. In the Pakistani culture, the well-being of the child is thought to be facilitated by adherence to Islamic teachings, intentionally applied Islamic rather than American cultural legal concepts. And so then the appellate court denied the jurisdiction. I will stop to mention here, and I meant to mention a minute ago, I was talking about that New Jersey case where the trial court judge was talking about public policy. What we found is all the states have public policy. But the problem is public policy changes. Public policy of the state of Texas is different from one end of the state to the other. And public policy is not codified. Every state has public policy, but there are no 2 states where the public policy is the same. So without laws like this, our trial court judges and our appellate judges are left to make these decisions based on public policy. The suggestion here is that we're at the point, we can't leave the future fortunes of protecting our laws to public policy. We need more. And that's what I was telling the Senate committee a year and a half ago. We need to equip and give our judges the tools to work with. I think that's what I was going to mention a minute ago. I forgot it. All right, so now the fourth prong of the proposed legislation. Any contract provision requiring that a foreign court or arbitrator adjudicate a suit affecting the relationships is void to the extent the arbitrator or foreign court would apply foreign law, and the foreign law as applied. The foreign law as applied would not guarantee the same fundamental rights guaranteed by the Constitution. So here we're dealing with, again, a contract provision that requires a foreign court to adjudicate. So that's a court of adjudication, right? That's what that's talking about. Well, guess what? We have a Texas Islamic court, as Linnell was saying, in Richardson, Texas, and it's been there since 1950, or some people are telling me a few years before. All right, the Jabri case is very disturbing. It comes from 03, and this was handed down from the appellate court in Fort Worth. What happens there is you have a standard divorce proceeding that's moving along at the trial court level, and wife is winning. There's custody going on. We have Texas-born children, and I don't remember if they were married or not in Texas. But midstream there, she's forced to signing an arbitration agreement. The arbitration agreement then says, we're going to take all of our issues out of the trial court, and we're going to send them over to this Texas Islamic court. And you're going to get your decision there. Well, that didn't go well at all, because they applied foreign law. She goes back to the trial court judge, and he gives her relief. Then that decision gets appealed, and the Fort Worth Appellate Court applied the foreign law and said to her, you signed this arbitration agreement that said that the Texas adjudicated matters that are already under Texas jurisdiction will not be decided under Texas law. Your contract says that you have submitted by agreement to foreign law, and you went and did that, and we can't help you. So they looked at the four corners of the page of the contract just to see if it was a valid contract. They didn't get behind it to look at and analyze what it really meant. They just looked at things like, was it dated? Is this your contract or signature? Was it witnessed? Is it clear and concise, or is it ambiguous or not? They kind of just did a contract analysis and left her on her way. So this is a very disturbing case, but you can see if this portion of the legislation existed, she would have won. And we would not have any court applying foreign law. And one of the things I'll mention as to what's the problem. Well, we talked about a few of them. Italic divorce is one. There's no due process. There's no equal protection. And the discovery rules don't apply like we're used to seeing, as well as the appellate rules. So I'll move on. The last case that illustrates the fifth part of the proposed legislation is a court of the state that has jurisdiction to adjudicate the suit in the relationship may not decline its jurisdiction because a foreign court is more convenient forum. If the foreign court would apply foreign law, that would not guarantee the same fundamental rights guaranteed by the Constitution. The Malat case out of California dealt with a couple that they were married in Lebanon or the UAE, I don't remember which, and things weren't going well. She flees to California and is living in hiding, as many of the women do. They come to the United States seeking refuge from these laws and the application of them. And she's been in California for a couple of years before she's found. She goes to the California trial court to get a divorce. He has jurisdiction over her and the child, as well as the marriage relationship. He denies jurisdiction, and he then allows the husband to go back to Lebanon. He actually files a talaq in the UAE and Lebanon, and she comes back and appeals that decision where the trial court judge denied the jurisdiction. And the appellate court says this: even though the trial court found that the Lebanese Islamic court did not appear to apply a best interest standard, and they found that there was no notice of any proceedings, they upheld the trial court's decision. So there is where this proposed legislation would keep, in this instance, a Texas judge from denying jurisdiction if they have it. I'll make this one very quick because I don't want to run out of time. This is an interesting case out of Missouri. This case, the folks were married in St. Louis, they had children in St. Louis, and they lived in St. Louis for a period of years. Now, and I might mention, under Sharia law, once the child reaches 7 or 8 or 9, depends on the domicile, the only way that under law she can, the wife, the mother, can continue to have the solid parental rights that she enjoys is to stay married or by consent. Because under a italic divorce, she becomes a legal stranger after that. She has no rights of possession, access, custody, those types of things. So in this case, we have a Saudi Arabia issue versus Missouri. And what happens is they all go to Saudi Arabia for a period of time. And then she wants to leave and he won't leave. He says, you can go, but I'm keeping my daughter here. And she leaves. And she stays in St. Louis for a period of time, finally coerces him into coming to St. Louis to bring the child for visitation. Prior to that, she gets a lawyer, gets a judge lined up, and they wait for them to come to St. Louis, and at the hotel, when she's got a little bit of time with her daughter, she leaves the hotel, quickly goes and gets a judge and gets a TRO. Now she's off to the races in getting a divorce, because he had done a talent divorce. Now we're talking here about folks that were married in Missouri, in St. Louis, a child that was born in St. Louis, and still residents of St. Louis. So the only thing that had happened was that he had come back, or she had come back rather in this instance, but he kept the child there and wouldn't come back. Well, this bounced back and forth, and after the TRO phase of it, she couldn't get a permanent injunction from the subsequent trial court judge because he bowed to the laws of Saudi Arabia and returned the child back to the father, back to Saudi Arabia, and then she appealed. Well, the appellate court from Missouri looked at this and said, well, ma'am, when were you ever divorced? And they couldn't prove that she was ever divorced. So then they completely reversed it, remanded it, and with some very strong words to the trial court judge, sanctioned him for abuse of discretion in refusing to apply jurisdiction, meaning that one before, or even determining best interest standard. And so she ended up winning this on appeal. It's kind of an interesting case. But the point I want to make here is we only get to read these cases after they've reached the appellate level. We really don't have any idea how many cases have to go down in this context before a litigant who's already disadvantaged has the funds and the energy and the resources to push this up to an appellate level where it gets the attention, and then we have a chance to read it. So we really don't know how many trial court cases that are out there. I will mention this last case before I move on. It's this MJR case. This falls outside of the family law arena, and in this case we've got a prearranged divorce, or excuse me, a prearranged marriage by parents. We have a MAR that's signed by, and the girl is a minor. Her husband, her future husband, is much older, and they are strangers. They don't even know each other. And they end up getting married, and within 6 months of being married and living in New Jersey, he begins his submission routine, okay? And it's violent, it's extreme, it's life-threatening, and it's frequent. The trial court judge in this instance made some horrible findings, or findings about horrible events that had happened to her. His findings weren't horrible, but depends on how you look at it. But even though he found that the beatings, the sexual abuses, she was even permanently injured, genitalia, all that kind of stuff was affected, he comes along and says, Judge, I didn't mean to do it. I was practicing my religion. I had no intent to do a crime. And he got exonerated from it. Completely exonerated from it because I think he actually stated in court, according to our religion, the wife should submit to anything asked. That's a quote that he made. And so the trial court judge found him to be absent what's called mens rea, that being the mental intent to do the bad act. And because that was absent, all he's doing is practicing religion, no harm, no foul. Okay, I'll skip some more, and
I find that there are only two things which are open to our movements: ballot or bullet, nothing in between.
Democracy, the black people freedom. No, we don't want to democratize Islam. We want to Islamize democracy.
Our job is to change the Constitution of America.
I find there are only two things which are open to our movement: ballot or bullet, nothing in between.
find that there are only two things which are open to our movements. Ballot or bullet, nothing in between.
Our job is to change the Constitution of America.
I think this might be a candidate for the YouTube. What do y'all think?
Yes.
Our job is to change the Constitution of America. That is from Saeed Saeed, Director of the Islamic Society of North America, ISNA, who is president, telling our legislators how to view the proposed legislation that I just went over with you.
I find
I'll move on. All right. I'm going to skip the comparison of the Constitution with Sharia. I think we got a pretty good handle on that. I will say as to the women's status, and I do a presentation on just women, Sharia and women issues, and it takes the full hour. But you can sum up where women stand in this comparison to a few words. Half the man. Half the man. Think of it in probate, inheriting intestate succession, half the amount. Think of it in death, for example. You have a wrongful death situation, half the amount. Abortion. If the child that's aborted, they don't agree with abortion, but if abortion occurs, there's blood money to be paid. If it's they find out that the child is a male, full blood money. Female, half blood money. If they're uncertain, what would you guess? 3/4.
Okay.
3/4. Anyway, half the man kind of sums it up, and there's a whole lot to talk about regrettably on the women's status. Let's see here. Let me cover. Okay, last April 2nd, this is what we ran into in the way of opposition. The ACLU, who is aware of these cases, said there's no threat in Texas of foreign law. Now, you remember I just cited a case in 2003.
Yeah.
I also cited another one in 2008. The American Bar Association attorneys came in citing freedom of religion and that we were trying to solve the problem. They actually said it was, quote, this is a bill, well, you were there, this is a bill looking for a home. Wasn't that what it was? This is a bill looking for a home. This one was really quite humorous. The lawyer representing the Texas Family Law Foundation went through a number of gyrations, all of which summed up to this proposed legislation that I just read to you would stop abortion.
Yes.
Pardon?
Yes. Yes.
Exactly. And then the Muslim Brotherhood and Linnell, I think it's fair to sum up what they collectively said was that our Constitution would not allow us passing a measure to protect our Constitution. I'm actually, okay, I've got in yellow here, y'all were talking about judges earlier. Our Judge Emerson in the Hill Country told me about 2 months ago, Chris, stay on this issue, we need to have it. I'm not going to get into details with you, but a couple of months ago, Judge Williams and I were in Dallas I believe it was Dallas, he mentioned, at our annual CLE. Believe it or not, judges do have to go to continuing legal education, as do all lawyers. And at that conference, that judicial conference, which only judges can go to, there was a question posed from the podium that said, how many of y'all are seeing Sharia in your courts? There was only about a dozen hands that went up, but as Judge Emerson was telling me later, what was disturbing was that about half of them boasted that they're not only is it in our courts, but we are letting it in on purpose. And I said, well, where are they from? He said, The ones that said that are basically from the DFW area. So to suggest that Texas doesn't have a problem is nothing other than a lie. It's intellectually dishonest. And what I'm also finding is that a lot of our judges are completely unaware of this issue. Let me skip ahead, and we'll skip some things on jihad. Or, you know. This is kind of an interesting quote right here. I'll play that, and then we'll get into the end of it. Back up. I'm sorry. Okay.
American society is not hardwired. The society doesn't have a rigid code. Alhamdulillah, we do have a code. We have a code. So that gives us an advantage because they are like jello and we are like a knife.
So there is jihad, the primary jihad according to the Quran is the jihad with the word. But there is jihad in the sense of fighting. There is no doubt about this. Islam is not a pacifist religion. Islam is a realistic religion.
The only obligation that we have to live in this country is dawah. Because, why am I saying that? Because we are paying taxes. These taxes are going to killing people, our brothers and sisters. So we better have a pretty good justification for what's here. The end goal of everything that we're talking about is the establishment, the re-establishment of the Islamic form of government.
Let me move down to my last slide, which is what to do. You know, I hate sometimes when you get a brand new laptop and you get everything all going and it just locks up. Before that pops up, and it will in a second, let me see if I can field some questions, and then I'll cover that last slide. You were first, right?
I tried to be first. A lot of the ones you used as an example, the contract or whatever was going on was started in a foreign country. And
the one in Texas did.
No, I understand the one where they were married here and they got beat up here and all that stuff. That's certainly our jurisdiction. But I don't fully understand why a woman can grab two kids and run into the United States and say, you've got jurisdiction over me when the whole thing was set up somewhere else. What gives us jurisdiction over something that wasn't initiated or set up or done here?
Yeah, that's a good question. What gives the woman the right to pick up, leave with the children, and flee to the United States for refuge?
Right.
Is that basically
Yeah, that's kind of the question, yeah.
Okay. What gives her the right to do that?
What gives us the right to dictate our solution?
Oh, okay.
What gives us jurisdiction over that?
The fact that she's here.
Right.
The fact that she's here.
That's it. That's all it takes.
That's it. In fact, in Texas, we have an emergency provision that doesn't have a minimum day count. Outside of the emergency provision, here it is. You have to have basically 6 months, okay? But if, and I had a case like this a couple of years ago where we had a woman and a daughter come from Alabama. And the father, this was a case that I was on, was in the military. And he cited jurisdiction for himself in his domicile, but he did not have the emergency provisions. So the daughter hadn't been with him for 6 months, and the court threw it out. But if you have the emergency provisions, and you can establish you've got an emergency going on, and we're here, Judge, we're right here in San Antonio, and we have this emergency. If you have that finding, that's what creates the power. In jurisdiction, you might think of it as power, the power to do something. Does that help you?
Yes.
Okay. The other question about what gives her the right to come here and flee for jurisdiction or flee for safety, that's a slightly different question.
Yeah, no, I was wondering why we think we have the authority to do it. You say it's an emergency and
And they're here. They're here. You don't get here, you don't get the protection of Texas. You were
My
safe,
question
right?
is kind of related because that is, what is the role of citizenship in this? I mean, she could have been born in this country or something. I mean, she might be a citizen. I mean, just hypothetically. So how is that, what does role of citizenship?
Are you speaking to immigration issues, or are you talking about, do we have one standard for U.S. citizens and one for non?
Yeah, I mean, that could be, I don't know. I mean, it's strictly jurisdiction.
Okay, help me with the specific.
Well, there was one that, on one of your slides, it mentioned that the person was a U.S. citizen, but and the others didn't. And so that made me wonder what role of citizenship played in this.
I have found in these cases, now like the one in Missouri, the one in St. Louis, where the folks, were married there and the child was born there and so forth, that seemed in dictum where the appellate court was analyzing what was going on. That seemed to carry some weight, but I would tell you academically that if they'd moved there 6 months earlier, it'd been the same outcome.
Oh, okay, all right. See, I just
Does that?
not being a lawyer, yeah.
No, that's okay, yeah.
Okay.
Dave was, okay, yes, sir.
You use the term Texas Sharia court. Now, does that have any legal status?
It's Texas Islamic Court.
Islamic court.
That's right, and it's in Richardson, Texas.
Yeah, but what is it?
It is a bank of Islamic arbitrators. And until the Jabri case came up, they basically were just spending their time. But once that Jabri arbitration agreement came in, and then it was tested, because after that happened, she left there and went back to the trial court judge, and he gave her relief. He threw it out. Well, then her husband appealed, and the Fort Worth appellate court said, no ma'am, you signed this arbitration agreement that put the adjudication of these Texas issues into the hands of these Islamic arbitrators who sit in Richardson, Texas, and we're going to force you to honor that contract.
What official status does this Islamic court have?
They didn't have any until their decision was upheld by the Court of Appeals. They had no way.
Just because the appeals court said, both sides over there are...
The rule of law that you would take away from that, the precedents, if you might, would then say to a zealous advocate of Sharia, would say, if you sign an arbitration agreement that requires Islamic law to adjudicate your issues, that's good in Texas. That's what they'll say out of that. I feel like I'm dodging your question, but I'm not meaning to.
No, I'm just kind of shocked that it came in the end. I thought an adjudicator had to be recognized by the state, by the law. There's laws that apply.
And I agree with you completely. That's why I said until the Court of Appeals gave weight to that, it had to.
Which Court of Appeals was it?
Fort Worth Court of Appeals.
But there's other arbitrators. I mean, there's arbitrators for stock market stuff. There's arbitrators for...
That's right. They were just private arbitrators.
And how is it any different than a private arbitrator?
How are they different than a private?
Well, I know the theory.
It's because they're applying foreign law to a Texas adjudicated issue. That's how I see it.
Normal arbitrators that people
You're saying that this act is going to refer to foreign law. Why does it not say foreign and religious or something? Because what could happen is that in another state, they may have, it might become considered American. I mean, I can see Dearborn considering this a Dearborn law or whatever. I mean, this is the law here,
I'm really glad you're on that question. The reason that the proposed legislation does not reference a direct foreign law, an example of that is what happened in Oklahoma. Our brothers to the north of the Red River got very zealous, and I don't blame them. In the proposed legislation, instead of saying foreign law, they said Sharia. Okay? And they passed it. It was a constitutional amendment to the state. 97% of the entire Oklahoma population voted for it.
Wow.
Well, Islamist took that to federal court, and he got kicked out for being unconstitutional because it discriminated against Islam, because Sharia is their legal code. So our Oklahoma lawmakers said, okay, that's fine. We'll take Sharia out, we'll put foreign law in, and they're back to the races. And so that's the only, I'm glad you mentioned that, man, because that is the only instance of where proposed legislation for ALAC has been constitutionally challenged, but it actually wasn't the proposed legislation. The proposed legislation doesn't say Sharia, and that's the reason why it opens the door to a constitutional attack. It's not been, outside of that one instance, it's not been a challenge.
Or even if it said foreign law or other laws outside of the Constitution and any state in the United States or something. Well, no, that wouldn't work, but I mean, I'm not a lawyer, so I'm just...
You had a question back here, sir.
Yeah, so if someone wanted to oppose this, could they not say that since its very founding, when courts were at a loss of how to decide a case, they would cite British common law or Napoleonic law in Louisiana, or you even mentioned the Bible earlier on, which wasn't written in the U.S., it's coming from Mesopotamia, right? So it looks like we have consistently cited foreign law. Am I wrong about that?
Well, I'm trying to get a grasp on your question now.
Precedent, it seems like it's been set for a long time that we have cited like British common law, for instance.
Well, British common law, in years and years ago, before we had our own jurisprudence, was a source of much of our common law as it was developing. Now, we did have lawmakers domestically, and they were busy making our laws, and did they, in fact, source back to the Bible for that? Absolutely, they did. But I don't see how the establishment
it seems like we're still it's like now we're saying, and I'm a friend, by the way.
No, that's okay.
I'm just saying it. So now we're saying we won't cite any foreign law.
Well, now we're saying...
It seems like we've cited foreign law all along.
Okay, I'll go with you there. But now we're saying that in 1785 we passed the Constitution. And since that time we have equal protection. We have due process. We have fundamental constitutional rights that have been adjudicated and evolved. When did women start to vote? 1921. You know, we've been in an evolution of trying to establish good civil law under a code that's consistent. That is our law. This is simply saying you don't get to apply foreign law here over a matter that is adjudicating our interest here. It's our interest here that's the issue. If you want to do it over there, that's fine. But if you're going to do it here over an inch, in other words, don't ask us to enforce a foreign law or a foreign judgment to a situation here if we can't reconcile what happened to create that to our own fundamentals. Because you're asking us to enforce something that cannot be reconciled to the Constitution, and we can't do it. Does that help you at all?
No, it helps. It still seems like there's probably situations where American courts might be at a loss, that perhaps a nearby Canadian court will have faced a very similar problem, and judges might cite, well, here's how Canada.
And Canada is a very good example. Britain's a good example. You know, many of these states have all signed the Hague Convention, for example. But see, they all have fundamental rights all in common. Those don't exist under Sharia. In other words, these foreign laws that you're citing, Canada doesn't strip a woman those rights to access at the age of 7.
I get it, but now, unfortunately, the word Sharia has been struck, but it's been replaced with the word foreign.
Well, it'd be informal if that foreign doesn't do that. If we're talking about a law from Qatar, and it can't be found that does embody those fundamental rights that we cherish here, then it's not going to be honored. But if it's a foreign law from France, and it does, then it will be. Yes, ma'am.
How about the United Nations laws? Does it protect us from those?
That's not a foreign law. That's not, the United Nations is not a foreign sovereignty. Let me say thank you very much. I'm sorry I ran.
No, we're fine. Let's give him a chance to go over his next slide before you leave. And I've tucked most stuff away, so just if you can scoot your chair to the back when you leave, give him a few more minutes.
Well, people say, okay, Chris, here's the problem, and what do we do? And so I put this slide in here to say we need to keep doing what we're doing right now, and that's conversing about things that matter, get informed and stay informed, and become aware and stay that way. I would encourage you to read Ezekiel 33, because it has some very good warnings to Israel for failing to set up a watchman, set up the alarm, and woe to the watchman if the watchman falls asleep at the switch, and woe to you if he sounds the alarm and you don't listen to it. Kind of an interesting quote. Proverbs 3:27 says, as long as you hold good, it's within your power to do so. Get organized and pray, and I will leave you with this. God directs the steps of the righteous. And I am proposing to you that we need to be that people, and we need to listen to those steps. This is a serious issue. If we talk this time next year, instead of 126 cases in 32 states, my prediction is we'll probably cover them all if something's not done. So we need to get this law passed in Texas. We need other laws passed in Texas that deal, and I didn't get a chance to get into some of those. There's some very good other laws that are out there that some of the other states are passing, but we're not even started yet with ALAC, so we need to do that. And then our job's not finished there. We need to then push it on out. So I thank you so much for coming and allowing us to come.
I just want to say thank you for coming, especially those of you who are new, those of you who brought somebody with you, woohoo. Next month,